Family court lawyers. What's the most petty behavior you've seen from parents? Story 1. The meth cook's wedding furlough. I'm a lawyer, and the most ridiculous argument I've ever made actually worked. My client got busted cooking meth. Not maybe he was cooking meth. They literally caught him mid-cook, surrounded by beakers and chemicals. Even worse, he was cooking at home with children present. The DA threw every felony at him. No bail, county jail, game over. My client knew he was screwed, but he had one request. Can I get out for 24 hours to get married? His wedding was planned for 2 weeks after his arrest. Non-refundable deposits, family flying in, the whole deal. I told him there was absolutely no way in hell they'd let him out, but he begged me to try. First, I asked the DA. They literally laughed in my face. He's cooking meth with kids in the house, and you want us to let him out for a wedding? Get real. So I did what any desperate lawyer does. I filed a motion with the court. Now I knew this judge, crusty old conservative, family values type who also had a raging hard-on for throwing the book at drug offenders. This should have been DOA. But I crafted an argument about the sanctity of marriage, how the state should encourage marriage at all times, how denying this ceremony would harm the innocent fiancé, how marriage promotes stability and rehabilitation. Complete bullshit, but I delivered it with a straight face. The hearing comes. I make my argument, knowing I'm about to be laughed out of court. The DA stands up. Your Honor, this is ridiculous. The defendant is a danger to society. He was cooking methamphetamine with children present? The judge nods, looks at me, looks at my client. Long pause. I'm granting the motion. The entire courtroom froze. The DA's mouth fell open. My client started crying. I nearly fell over. 24 hours. He must surrender at 8 a.m. sharp. Any violation, and I'll add 5 years to whatever sentence he gets. Everyone was stunned. The bailiff looked confused. The court reporter asked the judge to repeat himself. But it happened. My meth-cooking client got a day pass for his wedding. The wedding day arrives. He gets released at 8 a.m., gets married at 2 p.m., has a reception, and reports back to jail at 7:45 a.m. the next day. 15 minutes early. Everything went perfectly. No escape attempt, no drama, no violations. He served his time like a model prisoner afterward. To this day, I don't know why that judge granted it. Maybe he was having a good day. Maybe he respected that my client wanted to do right by his fiancée. Maybe he just wanted to see if we'd actually go through with it. But it worked. My drug-dealing client got legally married thanks to an argument about the sanctity of marriage made to a conservative judge. Story 2. The dog hostage situation. Law school intern at a family law clinic. Thought I'd seen petty divorces, but this one haunts me. Custody hearing. Mom wants the kids more often. Dad got the family dog in the divorce. Pretty standard so far. Then Dad drops the bomb. If I don't get more visitation with the children, I'll have the dog euthanized. The entire courtroom went silent. His excuse? Without the kids around, the dog won't get enough attention. It's more humane to put him down. Mom starts sobbing, pulls out photos of the kids playing with the dog, shows a video of the children saying how much they love their pet. The kids would be absolutely destroyed if anything happened to that dog. The judge is visibly disgusted, but legally hamstrung. The dog is Dad's property per the divorce agreement. He can legally euthanize a healthy animal. Mom's lawyer tries everything. Animal cruelty? Nope. Humane euthanasia is legal. Emotional abuse of children? Hard to prove. Extortion? Technically, he's just stating intentions about his property. Dad sits there smug, knowing he's found the perfect leverage. Mom caves, gives him basically every weekend of the month to save the dog. The supposed lack of attention problem magically disappears when he gets what he wants. The judge, to her credit, absolutely tore him apart verbally, warned him she'd be watching closely. Any slip-up with the kids or the dog, and she'd revisit custody. Made it crystal clear that if that dog died under suspicious circumstances, she'd fast-track a custody hearing. Sir, you've shown this court exactly what kind of father you are. One who would kill a family pet to hurt your children's mother. I'm legally bound by the custody agreement, but I'm also legally bound to protect these children. One mysterious accident involving that dog, and you'll see how creative I can get with custody arrangements. That day, I realized family law wasn't for me. What kind of person uses a living creature as a bargaining chip? What kind of father would traumatize his own children to get more weekends? The dog lived, but those kids learned their dad would kill something they loved to win a fight with their mom. Some people shouldn't have custody of children or pets. Story 3. When you object to your own evidence. I'm in trial trying to enter a document into evidence through the opposing party's witness. Pretty standard stuff. The witness identifies it. Yes, this is one of our business records. Opposing counsel jumps up. Objection, authenticity. The jury's watching, so the judge calls us to sidebar. Opposing counsel argues the document isn't authentic. I'm confused, but then it hits me. Your Honor, I say, trying not to smile, this is theirs exhibit. They submitted this to the court. The judge turns to opposing counsel. Are you telling me you submitted non-authentic documents to this court? You could see the lawyer's brain short-circuit. He'd been so focused on blocking me, he forgot it was his evidence. No, I mean, it's authentic when we use it. So it's only authentic sometimes? That's not what Counselor, did you or did you not submit this document? Yes. Then it's authentic. Overruled. The document goes in. The jury saw the whole sidebar dance, saw opposing counsel object to his own evidence. Sometimes lawyers get so caught up in fighting everything that they fight themselves. This guy literally argued his own evidence was fake just to stop me from using it. The best part? It was a receipt showing his client owed money. He could have let it slide, but by making a scene, he drew the jury's attention to exactly what he didn't want them to see. Moral: know your exhibits, and maybe don't accuse yourself of fraud in open court. Story 4. Fighting over blood money. Law school. Working on the worst case imaginable. Parents of a Sandy Hook victim divorced before losing their child. Still fighting over child support years later. Now fighting over who gets the victim's compensation fund money. These people were insanely rich. This wasn't about needing money, it was about winning against their ex. They weaponized their dead 6-year-old's memory to score points in their divorce. Every filing mentioned their murdered child, but only as leverage. She would have wanted me to have this money. He never cared about her like I did. Using their baby's death as ammunition. The other children were stuck watching their parents fight over their dead siblings' blood money. Legal documents full of accusations. Each parent claiming the other didn't grieve properly. Fighting over who missed her more. Who deserved compensation for their loss. As if you could quantify a child's death in dollars. As if winning meant anything when your baby was gone. The worst part? They had millions already. This wasn't about survival or even comfort. Pure spite, dressed up as grief. The judge looked disgusted every hearing. But legally, someone had to get the money. The state had to decide which parent deserved compensation for their murdered child. I quit law school for a semester after that case, came back, but never touched family law again. Some cases show you the worst of humanity. Parents who care more about beating each other than honoring their dead child's memory. That money was meant to help grieving families. Instead, it became another weapon in their endless war. Story 5. The 33-minute smoking gun. Intern on a custody case. Dad wants more time with his son, claims mom is irresponsible. His evidence? A detailed log of every time mom was late for pickup. Detailed, like CIA-level surveillance of tardiness. I'm going through Discovery and find this masterpiece. Mother's punctuality record, a 6-month analysis. Spreadsheets, timestamps, color coding. This man documented every pickup for 6 months, down to the second. Total tardiness over 6 months? 33 minutes. They met 3 times a week for exchanges. That's roughly 78 meetings. She was late 33 minutes total, not per incident, total. That's about 25 seconds per meeting. Sometimes she'd be 2 minutes late, once a week. But this man treated it like evidence of gross negligence. Had graphs showing patterns of tardiness, pie charts of punctuality failures. My favorite entry? March 5th. Mother arrived at 6:01:17 p.m. Pickup time was 6 p.m. This represents a 0.02% violation of our agreement. The client was adamant we use this in court. It shows a pattern of disrespect for court orders. Sir, she averaged less than 30 seconds late per pickup. Exactly, chronic tardiness. The judge actually laughed when we presented it. Not a chuckle, full laugh. Sir, do you know how long I've been waiting for this hearing to start because your lawyer was in another courtroom? 20 minutes. Should I remove your custody? Case dismissed. Dad got exactly 0 extra time with his son. Spent thousands in legal fees to prove mom was occasionally 1 minute late. The kicker? His own punctuality record showed he'd been late 14 times, but those were unavoidable delays due to traffic. Some people have too much time and not enough sense. Story 6. The Great Pork Dispute. Family law assistant here. Divorce asset division gets weird, but this takes the cake. Or, should I say, the pork. Client includes in her asset list one pork shoulder, frozen, approximately 4.2 pounds, located in basement freezer. Not the contents of the freezer, just that specific chunk of pork. Her lawyer tries to reason with her. The pork is maybe worth $20. Legal fees for discussing it, $300 per hour. It's the principle, she insists. I bought that pork for Easter dinner. It's mine. Opposing counsel receives the asset list. Calls our office. Is this a joke? No, she's very serious about the pork. Long pause. I'm not going to argue over second-hand meat in a freezer. But the wife insists. That pork represents something to her. Maybe the last normal grocery trip before everything fell apart. Maybe she just wants to win something. 3 emails about the pork. 2 phone calls. 1 heated exchange where she accused him of planning to invite his girlfriend over for her pork dinner. Final agreement. She gets the pork, he gets the freezer. She drove 40 minutes to collect one frozen pork shoulder from a house she'd lived in for 20 years. Total legal fees spent discussing the pork, $1,300. Value of pork, $20. The look on her face when she got that pork, priceless? No, still insane. Sometimes winning is just about winning, even if what you win is meat that's been in a freezer so long it probably has freezer burn. Story 7. The Make-A-Wish Disaster. Attorney's office story that still makes me sick. Divorce case. Child has terminal illness, maybe a few years left. You'd think facing every parent's worst nightmare would make people prioritize. Nope. The Make-A-Wish Foundation approaches. The kid qualifies, gets to make one wish. Every dying child's small bright spot in the darkness. The parents went to war over what the wish should be. Mom wanted Disney World. Dad wanted a celebrity meet and greet. Kid just wanted their parents to stop fighting. They filed motions about their dying child's wish. Mother is attempting to monopolize child's final meaningful experience. Father is denying child age-appropriate enjoyment. Using legal language about their baby's last wish. Filing briefs about whether Mickey Mouse or a pop star would create better final memories. The judge lost it, absolutely tore into both parents. But legally, he couldn't force them to agree on the wish. Here's the part that breaks your heart. The kid found out about the fighting, realized their last wish was causing another battle. The child refused the wish. Let that sink in. A terminally ill child gave up their Make-A-Wish because their parents couldn't stop fighting long enough to let them have one magical moment. The disease took the child 2 years later. Both parents spoke at the funeral about how much they'd sacrificed. Neither mentioned the wish their baby never got to make. Some cases make you question humanity. This one made me certain some people don't deserve children, especially dying ones who just wanted their parents to love them more than they hated each other. Story 8. The Great Tupperware Lid Heist. Dad won everything in the divorce because Mom had untreated mental illness, alcoholism, and a meth hobby. Standard sad story until the aftermath. Mom decided to wage psychological warfare through Tupperware. Started breaking into our house when we were gone. Her calling card? Stealing all the Tupperware lids. Just the lids. Left the containers. You ever try to find matching lids for 47 random containers? It's hell. We'd buy new sets. Come home from school, all the forks gone. Just forks. Spoons and knives remained. Dad, why can't we ever have complete silverware? Your mother's making a point. What point? I honestly don't know anymore. Next week, buy forks. Come home. All spoons gone. We installed locks and security cameras. 3 days later, we're reviewing footage of Mom literally stealing our window. The actual window. Removed it from my bedroom and ran down the street carrying it. The police couldn't stop laughing when we showed them the video. Ma'am, did you steal a window? It's my window. I picked it out. You ran down the street with it? Jogging is healthy. Yes, we have a restraining order. Yes, she still steals random stuff. No, you can't put a crazy person in a mental hospital unless they're a physical threat. Current missing items? All the S Encyclopedia volumes, exactly 7 coat hangers, 1 flip-flop, just the left, the number 4 from our house address, all the batteries from remotes, but not the remotes. We play What Did Mom Steal Now every time we come home. It's weirdly become family bonding. Dad doesn't even get mad anymore, just sighs and adds it to the list for insurance. She took the toilet seat, just the seat. Of course she did. Story 9. The Chef Boyardee Emergency. Phone rings at 11 p.m. Client calling with an emergency. I'm thinking custody violation, domestic violence, someone fled with the kids. Real emergency stuff. She fed our son Chef Boyardee for dinner. Is he allergic? No. Was it expired? No. Then what's the emergency? It's processed food. The custody agreement says healthy meals. Sir, it's 11 p.m. This is child abuse. It's pasta in a can. Exactly. This man wanted me to file an emergency motion at 11 p.m. over SpaghettiOs. Do you know what's in Chef Boyardee? Chemicals. Everything is chemicals. Water is chemicals. She's poisoning our son. With ravioli? He ranted for 20 minutes about preservatives, sodium content, and artificial flavoring, had screenshots of the can's nutrition label, wanted to subpoena the grocery store receipt. We need to demand she provides meal plans, weekly menus, nutritional breakdowns. Sir, that's not how custody agreements work. Then we sue Chef Boyardee. For what? For enabling bad parenting. I went to law school for this. 6 figures in debt to argue about canned pasta at midnight. Told him unless the child was hospitalized, there was no emergency. He fired me the next day. Found out later he went through 4 more lawyers trying to build his Chef Boyardee negligence case. His new girlfriend was apparently a nutritionist who convinced him processed food was child abuse. The kid? Probably just happy he got to eat something normal for once instead of organic kale smoothies. Sometimes I miss corporate law. At least there, when people fight over stupid things, millions of dollars are involved. Not $1.50 worth of canned pasta. Story 10. The Dog Didn't Suffer Defense. I'm a lawyer. Colleague had a robbery case that went sideways. Literally argued shooting a dog wasn't animal cruelty because it didn't suffer. This wasn't euthanasia. This was a robbery where the criminal shot the family dog during the break-in. Defense attorney stands up. Your Honor, while unfortunate, shooting the dog doesn't constitute animal cruelty because the death was instant. No suffering occurred. The judge actually entertained it for a second. You could see her processing. Is he really arguing that murdering a pet during a felony is okay if you aim well? Prosecutor, the defendant shot a dog during a robbery. Defense, but it was a clean shot. Judge, are you seriously arguing that marksmanship negates animal cruelty? Defense, if the animal didn't suffer. Judge, so if I shoot you cleanly, it's not assault? Defense, that's different. How? The courtroom was silent. Even the defendant looked at his lawyer like, what are you doing? The judge came to her senses. Counselor, you just argued that murdering pets is fine if you do it efficiently. Rethink your life choices. Motion denied. The lawyer tried to recover. I'm simply saying the suffering component. Stop. Just stop. You're making it worse. The defendant got convicted of robbery and animal cruelty. The clean-shot defense probably added years to his sentence just for pissing off the judge. Sometimes lawyers get so caught up in technical arguments they forget they're talking about someone shooting a family dog during a crime. But did it suffer? Isn't the winning argument you think it is when you're defending a puppy killer. Story 11. The Danish Courtroom Math. Famous case from Danish High Court that became legal legend. A woman was raped by 8 bikers on a beach. Horrific case. Clear evidence. The defense attorney, in his infinite wisdom, argued, she put herself in that situation. She was alone with 8 men. She should have known what would happen. Basically, the "she was asking for it by existing near men" defense. The female prosecutor didn't miss a beat. She looked around the courtroom slowly, counting. Let's see. 1, 2, 3. She pointed at each man. 11 men in this courtroom, and I'm the only woman here. She paused, spread her arms wide, and delivered the killing blow. So, by your logic, I'm asking for it right now? Dead silence. Then something unprecedented. Every single judge burst out laughing. Not chuckles, full, hearty laughter in a rape trial. The defense attorney turned red, stammered, tried to backtrack. Too late. The prosecutor had just demonstrated the absurdity of his argument using the courtroom itself. If being outnumbered by men equals consent, then she was consenting to the entire courtroom at that moment. The judges composed themselves, but the damage was done. The defense's entire argument collapsed in 10 seconds of counting and one perfect question. All 8 bikers were convicted. The case became required reading in Danish law schools as an example of both the worst defense possible and the best prosecutorial response. Sometimes the most effective legal argument isn't citing precedent or complex law. Sometimes it's just counting the men in the room and asking one perfect question. That prosecutor didn't just win the case. She destroyed an entire category of victim blaming in one brilliant moment. Story 12. The Unisex Armani Hoodie War. Intern at a law firm. Divorce case. You'd think rich people would fight over houses, cars, investments. Nope, these two went to war over a hoodie. Not just any hoodie, a unisex Armani hoodie. Gray, size medium, probably $500 retail. The email chains were insane. Hundreds of messages about one hoodie. It was a gift from my mother. You gave it to me for Christmas. I let you borrow it. Borrowing for 5 years is called owning. They hired forensic accountants to trace the purchase, subpoenaed credit card records, took depositions from friends about who wore it more. Wife, he only wore it twice. Husband, she stretched out the sleeves. Wife, it's unisex. Husband, it smells like her perfume. Mediation sessions devoted entirely to hoodie custody, proposed solutions, alternating weeks, seasonal custody, he gets fall-winter, she gets spring-summer, cut it in half, Solomon style, buy identical hoodie, rejected, not the same memories. Finally, husband wins the hoodie in the settlement. Victory. Wife's response? Cuts holes in it. Strategic holes, right where the seams meet so it falls apart when worn but looks fine on the hanger. Husband discovers this during his first triumphant wearing. Hoodie literally disintegrates at a business dinner. He tries to sue for destruction of property. She claims it was normal wear and tear. $30,000 in legal fees, over a hoodie that ended up in the trash. The best part? I saw the hoodie during document review. It was nice, but nothing special. You could buy 10 of them for what they spent on lawyers. But it wasn't about the hoodie. It never is. It's about winning something, anything, from someone you used to love. Story 13. The Coaching Catastrophe. Worst case I've seen, mother coaching her 2 kids to claim dad was abusive. Physical abuse, sexual abuse, the works. This wasn't subtle. She literally rehearsed their stories with them like lines in a play. What gave it away? First, the court-appointed psychologist caught inconsistencies during interviews. Kids would use adult phrases no child would know. Legal terminology. Same exact wording. The psych report was 280 pages. I've never seen one that long. Page after page, documenting how the stories didn't match reality. But the real bombshell? The 10-year-old got mad at mom over something trivial, probably screen time or bedtime. Kid grabbed mom's phone and hit record. Caught mom red-handed. Remember, you tell them daddy touched you here. Say it made you feel scared. Can you cry when you say it? The kid recorded 20 minutes of coaching, mom going through the whole script. If they ask why you didn't tell anyone before, say you were scared. Dad's lawyer played it in court. You could hear everyone's hearts break. The judge looked ready to explode. Mom tried to explain, I was just preparing them for testimony. Judge, by teaching them to lie about abuse? Mom, it's not lies if... Judge, stop talking. Dad got full custody. Mom got supervised visits for 13 months. Should have been longer. Those kids needed therapy to unlearn the lies their mother taught them about their father. Imagine growing up, not knowing which memories are real and which ones mom planted. The recording saved those kids. Without it, Dad might have gone to prison for crimes that existed only in mom's sick imagination. Some people will destroy their own children to hurt their ex. It's the worst thing I see in family court. Kids turned into weapons. Story 14. The jailhouse reconciliation that still makes me laugh. Guy fresh out of prison, 2 years, marriage rocky as hell. Standard post-incarceration drama. Wife drops kids for visitation. Son mentions uncle hit him. Dad immediately files protection from abuse order against wife and uncle. Granted. Then files for emergency custody. Also granted. Kids with dad for 2 months. Custody hearing coming up. My boss throws me the file last minute because of course he does. Mediation day. Mom and dad sitting across from each other, arms crossed, shooting death glares. The tension could be cut with a knife. Other lawyer and I step out to discuss settlement options. 10 minutes, that's all. We come back to find our clients gone. Check the hallway. Nothing. Check the bathroom. Nothing. Check the parking lot. Found them in a corner, making out like teenagers. What's happening? We worked it out. By kissing? We're getting back together. 2 months of litigation, PFA orders, emergency custody, thousands in legal fees, solved by 10 minutes alone, and apparently some really persuasive kissing. Case dropped. They left together, holding hands. The other lawyer and I just stood there. Did that really just happen? Best part? This was pro bono. I did 2 months of work for free so they could make out in a courthouse hallway and decide they loved each other again. 3 months later, she filed for divorce. But for one shining moment, courthouse PDA solved everything. Sometimes love is weird. Sometimes it's really weird. Sometimes it involves dropping assault charges because someone's a good kisser. Family law, folks, where logic goes to die. Story 15. The Professional Victim Coach. Worst manipulation I've seen. Mom was a social worker trained to interview child abuse victims. Used her professional skills to coach her kids into false accusations. She knew exactly how real victims act. Taught her kids to display all the right trauma responses. The hesitation, the looking away, the reluctance to share details, all performed perfectly. She'd take them to Child Protective Services repeatedly. Kids would sit there while mom did all the talking. They're too scared to tell you what teenage cousin did, but I know the signs. Every visit documented. Every medical exam, all negative. But she kept going back. Different CPS workers each time, hoping one would bite. The medical records were damning. Page after page. Mother reports child said X. Child did not speak during examination. Physical examination, normal. What sunk her? She got cocky. Started coaching the kids to add details that hadn't been in earlier reports. CPS workers compared notes and realized the story kept evolving. Plus, one kid finally broke. Mom said if we don't tell them about cousin, Dad will take us away forever. Using her professional training to weaponize her own children against an innocent teenager. She knew how the system worked and tried to manipulate it. Lost custody immediately. Criminal charges filed for false reporting. The cousin? Straight A student who'd never been alone with the kids. His life almost destroyed because Aunt needed ammunition in a custody battle. Some people shouldn't work with vulnerable populations. Some people definitely shouldn't have kids. Story 16. The 25-minute, $400,000 war. California custody case. Mom, dental hygienist, divorces dentist number 1 for dentist number 2. She wants to move with kids to dentist number 2's town to work in his practice. Distance? 25 minutes. 25 minutes! Not crossing state lines, not hours away, less than half an hour. Dentist number 1 loses his mind. Can't have his kids living 25 minutes away. That's basically abandonment. Think of the commute. They spent $400,000 fighting over 25 minutes. $400,000. Expert witnesses on how 25 minutes impacts child development, traffic studies, psychological evaluations about community disruption, depositions about drive times during rush hour versus non-peak times, GPS data submitted as evidence, alternative route analysis. Your Honor, in morning traffic, it's actually 32 minutes. Objection! That's only on Tuesdays. Meanwhile, I'm realizing dentists make way too much money if they can blow $400K on this nonsense. Should have been a dentist. The judge looked dead inside by the end. You've spent enough money to buy a house in the town you're fighting about. You could have each bought houses there. Final ruling? Mom can move. 25 minutes isn't significant. Shocking conclusion that required $400K to reach. Both dentists probably extracted a lot more teeth than necessary that year to pay their lawyers. Sometimes rich people need better hobbies than litigation. Story 17. The Happy Faces Daycare Emergency. Staff attorney for a judge. Colleague handles family law. Gets an emergency motion filed. For non-lawyers, emergency equals someone might die, get kidnapped, or suffer irreparable harm. Needs hearing within days, not months. This emergency, little Timmy needs to attend Happy Faces Daycare. Not a daycare, specifically Happy Faces. If he can't attend Happy Faces, he'll suffer irreparable developmental damage and social isolation trauma. The motion included expert testimony about Happy Faces curriculum, comparison charts of local daycares, testimonials from Happy Faces parents, a child psychologist's evaluation somehow obtained in 2 days. Emergency relief is required as enrollment closes Friday and child will be forced to attend inferior daycare, causing lasting psychological harm. The other parent's response, it's daycare. He's 3. He eats paste. Judge's ruling, while the court appreciates the apparent excellence of Happy Faces Daycare, the court finds no emergency exists. Child's attendance at Sunshine Academy or Little Learners will not constitute irreparable harm. Motion denied. But Your Honor, Happy Faces has the best finger painting program. Motion denied. Parents spent $5,000 on an emergency motion for specific daycare placement. Could have paid for a year of any daycare with that money. Later found out, Happy Faces was closer to Mom's gym. That's it. That was the emergency. Family court, where parents spend college funds fighting about preschool. Story 18. It wasn't hit and run because I wasn't driving. Public defender here. Client charged with hit and run after his car rolled away from a gas pump, crashed through a stop sign, and ended up in a ditch. All caught on video by a passing city bus. Here's what happened. Guy parks at gas pump, goes inside. Car starts rolling. He left it in neutral. Rolls across the parking lot, over the curb, destroys a stop sign, lands in ditch. Client runs out, sees his car in the ditch, gets in, and speeds away. Also, his license was suspended. His defense? I wasn't driving when it hit, so it's not hit and run. Me. Okay, you have half a point, but what about the run part where you drove away? Him. But I didn't hit anything while driving. Me. You still ran from an accident. Him. An accident I didn't cause. The car caused it. Your car, that you left in neutral. Him. Gravity caused it. The video was beautiful. Shows him sprinting to the car, jumping in, throwing mud everywhere as he speeds away. Definitely driving during the run portion. He wanted me to argue that hit and run requires you to be driving during both the hit and the run. That since these were separate events, it wasn't the crime of hit and run, but rather hit, then later run. Your Honor, my client commits to two separate acts, involuntary hitting and voluntary running. Neither alone satisfies the statute. Judge. Nice try. Guilty. Took the plea deal. But somewhere in an alternate universe, there's a law school exam question about whether you can commit hit and run if your car hits something without you in it. Answer? Yes. Yes, you can. Story 19. The mature 2-year-old. Canadian family lawyer. Parents say the wildest things with straight faces. Client comes in. I think my son is mature enough to decide when he sees his mother. Me. How old is your son? 2.5. Your 2-year-old? He's very mature for his age. He's 2. He can make choices. He picks his own clothes. Between the dinosaur shirt and the truck shirt? He's very decisive. Sir, does your son still wear diapers? Pull-ups. He's transitioning. But you think he can decide custody schedules? Why not? Had to explain that 2-year-olds also choose to eat dirt and stick fingers in outlets. Maybe not the best decision-makers for legal matters. Another gem. Parents fighting because mom picked up kid at 10 p.m. instead of 6 p.m. for her visit. 4 hours late. Dad calls screaming, file contempt charges. She was late. It happens. 4 hours. Did you have plans? No, but it's the principle. Spent 3 hours talking him down from filing contempt over a one-time lateness. Best petty fight? Mom wouldn't let Dad take kids to Disney because she wanted to take them first. She couldn't afford it, had no plans to go, just didn't want him to create that first memory. Judge. So you're denying them Disney because you might someday take them? I should be their first Disney experience. When? Eventually. Kids went with Dad. Mom spent the week posting passive-aggressive Facebook memes about real parents make memories, not buy them. Some parents forget the co in co-parenting stands for cooperation, not competition. Story 18. It wasn't a hit and run because I wasn't driving. Public defender here. My client was charged with hit and run after his car rolled away from a gas pump, crashed through a stop sign, and ended up in a ditch. The entire thing was caught on video by a passing city bus. So here's what happened. The guy parks at the pump and goes inside the station. His car, which he left in neutral, starts rolling. It rolls right across the parking lot, over the curb, completely destroys a stop sign, and finally lands in a ditch. The client runs out, sees his car, and what does he do? He gets in and speeds away. Oh, and his license was suspended at the time. His defense was a masterpiece of logic. He said, "I wasn't driving when the car hit the sign, so it can't be a hit and run." Me, "Okay, I see your point, but what about the run part, where you very clearly drove away from the scene?" Him, "But I didn't hit anything while I was driving." Me, "You still ran from the scene of an accident." Him, "An accident I didn't cause, the car caused it." Your car that you left in neutral. No, gravity caused it. The video footage was just beautiful. It shows him sprinting to the car, jumping in, and throwing mud everywhere as he peels out of the ditch. He was definitely driving during the run portion of the events. He genuinely wanted me to argue that the crime of hit and run requires you to be driving during both the hit and the run. That since these were two separate events, it wasn't one crime, but rather a hit and then a later run. His proposed argument for the judge was, "Your Honor, my client is guilty of two separate acts, an involuntary hitting and a voluntary running. Neither act alone satisfies the statute." The judge's response was priceless. "Nice try. Guilty." He took the plea deal. But I'm convinced that somewhere in an alternate universe, there's a law school exam question about whether you can commit a hit and run if your car hits something without you in it. Story 19. The Mature 2-Year-Old. I'm a family lawyer in Canada, and let me tell you, parents will say the wildest things with a completely straight face. A client comes into my office and says, "I think my son is mature enough to decide for himself when he sees his mother." Me, "Okay, and how old is your son?" Him, "He's 2.5. Me, "Your 2-year-old? Him, "He's very mature for his age." Me, "He is 2. Him, "But he makes his own choices. He even picks his own clothes." Me, "You mean he chooses between the dinosaur shirt and the truck shirt?" Him, "He's very decisive." Sir, with all due respect, does your son still wear diapers? Pull-ups, he's transitioning. And you believe he's equipped to make legally binding decisions about his own custody schedule? Why not? I had to gently explain that 2-year-olds also choose to eat dirt and stick their fingers in electrical outlets, so perhaps they aren't the best candidates for making major life decisions. Here's another gem. I had parents fighting because the mom picked up their child at 10 p.m. for her visit instead of the agreed-upon 6 p.m., 4 hours late. The dad calls me, absolutely screaming, "I want you to file contempt charges now." Me, "Okay, she was late. It happens sometimes." 4 hours late. Did you have to cancel important plans because of it? No, but it's the principle of the thing. I spent the next 3 hours talking him down from starting a legal war over a one-time scheduling mistake. But the best petty fight? A mom wouldn't let the dad take their kids to Disney World because she wanted to be the one to take them for the first time. The problem was she couldn't afford it and had no actual plans to go. She just didn't want him to create that first memory. The judge was baffled. Judge, "So you're denying your children a trip to Disney because you might want to take them someday?" Mom, "I should be their first Disney experience." Judge, "And when will that be?" Mom, "Eventually." The judge ordered that the kids would be going with their dad. The mom spent the entire week posting passive-aggressive memes on Facebook with captions like, "Real parents make memories, they don't buy them." It's amazing how. Story 20. The shipping container custody case. I represented a mom in a custody case where the dad was a special kind of awful. He had gone to the Philippines, found a young woman, and romanced her by promising a better life in Australia. He brought her over, then treated her like an unpaid servant who also happened to give him children. When she finally found the courage to leave, he manipulated her. He made her believe they could share custody without any court orders. While she was trusting him, he secretly filed for sole custody and won by default, simply because she didn't know she had to respond to the court. By the time she could afford a lawyer to fight back, he'd had kids for months. His arguments in court were spectacular. He made wild accusations, claiming she's a bad influence, even though she worked a normal job at a grocery store and lived in a modest apartment. Meanwhile, he was living in a modified shipping container with his new girlfriend. There were no actual walls between his bedroom and the kids' room, just curtains. But somehow, the mom was the bad influence? The best moment was when he told the judge he knew the exact date of conception because, and I quote, "I have superior personal control over my biological contributions." The judge just stared at him. That's not relevant to a custody hearing. Him, "It shows I'm a person who was in control." Judge, "Of your..." Never mind. Moving on. He represented himself, so every document he filed was comedy gold. According to him, every scraped knee, every bad grade, every sniffle the kids got was the mom's fault, from her limited visitation time. Kid gets a B in math. The mother's negative influence is affecting his studies. Kid catches a cold, a result of the mother's poor hygiene habits. Kid doesn't like broccoli, the mother's permissive feeding has destroyed his palate. He lost, spectacularly. He went from having full custody to getting them every second weekend. It turns out judges don't appreciate luring women from overseas with false promises, raising children in a shipping container, claiming your unique personal control makes you a good parent. The mom got her kids back. The dad was ordered to have supervised visits until he found suitable housing that included actual walls. Story 21. The Diabetic Candy Trap. This is one of the worst things I've seen in a custody battle. The dad wanted full custody. Their child had diabetes and required constant glucose monitoring. Both parents were required to log the child's blood sugar readings. This is standard diabetes management. What the dad didn't tell me was his strategy. Every single time he dropped the kid off at the mom's house, he would first stop at a gas station and buy candy, Snickers, Twix, whatever was packed with sugar. He'd tell his son, "Here, buddy, don't tell your mom." The child's blood sugar would, of course, skyrocket right around the time the mom took her first reading. Her logs always showed dangerously high numbers. The dad's logs, from his time with the child, were always perfect. In court, the dad proudly presented months of glucose logs. "Look at these charts. Every time he's with his mother, his blood sugar spikes. She is clearly unable to manage his diabetes." The mom was in tears, swearing she followed the diet perfectly and couldn't understand why the readings were always so high. The judge looked grim and was on the verge of transferring custody based on what looked like clear medical neglect. But then the dad's smugness gave him away. He shot this little smirk at the mom as the judge was reviewing the charts. In that instant, she realized what was happening. She blurted out, "Check the timestamps, Your Honor. It's always within 30 minutes of the drop-off." The dad started to panic. So what? She probably feeds him something bad right away. The mom shot back. Ask him what he feeds our son in the car on the way to my house. Dad, nothing. I would never. The child's doctor, who was present as an expert witness, interrupted. Your Honor, these sudden spikes are consistent with the consumption of 40 to 50 grams of pure sugar approximately 20 minutes before the reading is taken. The truth came out. The dad had been deliberately sabotaging his own diabetic child's health to build a case against the mother. He was using his son's life-threatening condition as a weapon to win custody. The judge's demeanor went from sympathetic to furious in a split second. The dad didn't just lose the case, he lost all his unsupervised visits and was facing criminal charges for child endangerment. On a lighter note, I had another client who tracked his ex-wife's toilet paper usage. He came in with spreadsheets. She uses 3.7 sheets per visit. The national average is 2.1. That's a 75% waste of our shared assets. He had also tracked her water usage, her electricity, and even how many steps she took inside the house using fitness tracker data he got during discovery. He argued this proves she's financially irresponsible. I told him, "Sir, this proves you're insane. Some people shouldn't have access to Excel, or children, or a diabetic child's candy supply."
Story 22. When will I see you again? Interim custody order stated mom couldn't discuss court proceedings with child. Standard stuff. Don't drag kids into adult problems. During a visit, child asks mom, "When will I get to see you again?" Any parent's heart would break. Mom responds, "We'll have to see, but hopefully soon." That's it. That's the whole conversation. Dad files contempt charges, claims this was discussing court proceedings. His argument, by saying "we'll have to see," mom was referencing the custody battle. By saying "hopefully soon," she was discussing potential outcomes. Your Honor, she clearly indicated that court proceedings would determine future visits. Judge, she said "hopefully soon" to a child asking when they'd see their mother again. Dad, exactly. Hopefully implies uncertainty caused by legal proceedings. Judge, or it implies hope? Dad, she should have given a specific date. Judge, which she doesn't know because of the proceedings she can't discuss. Dad, she could have said something else. Judge, like what? I don't know. Something that doesn't reference court. Judge, how does a mother answer when she'll see her child without referencing the thing preventing her from seeing her child? This went on for an hour. Dad's lawyer tried to argue that any expression of uncertainty constituted discussion of proceedings. Judge's ruling. This court will not punish a mother for expressing hope to see her child. Motion denied. And sir, if you file another frivolous contempt motion, you'll be paying her legal fees. Dad tried to appeal based on the judge being biased toward mothers who express hope. Appeal denied. Some people will weaponize anything, including a child's innocent question and a mother's hopeful response. Story 23. The Divorce File Olympics. Appellate court clerk. Different cases had predictable file sizes. Criminal cases, 2 to 3 inches. Quick trials, short briefs. Civil cases, 5 to 6 inches. Expert testimony, procedural warfare. Death penalty cases, 12 to 15 inches. Serious crimes, constitutional issues. Divorce cases with kids, measured in feet. One case literally took up an entire filing cabinet, 5 feet of documents. Why? Because these parents went to court for everything. Which school? 47 pages of arguments. Bedtime, medical experts testified. Haircuts, constitutional right to bodily autonomy argued. Vitamins, see below. The Flintstones vitamin case became legendary. Dad didn't want mom giving the kid multivitamins. His arguments,
Artificial colors cause ADHD. She's medicating without consent. Vitamins are gateway drugs. Mom's response, they're Flintstones vitamins. 3 hearings, expert testimony from nutritionists, thousands in legal fees. Over a bottle of chewable Barneys and Bettys? These parents couldn't agree on anything, so the judge became the parent. Every decision went through court. Summer camp? Judge decides. Birthday parties? Judge approves guest list. Vegetables? Judge rules on serving sizes. They spent their kids' college funds fighting over elementary school. Gave up all parental authority because they couldn't compromise on vitamins. The judge essentially raised their kids through court orders. Child shall consume 1 Flintstones vitamin daily, alternating between grape and orange flavors. When you can't co-parent, the state becomes the parent, and the state charges by the hour.
Story 24. The Incest Accusation Nuclear Option. Family case from hell. Uncle and aunt divorcing. Uncle completely lost his mind. Started normal crazy. Claimed aunt was unfit because she worked too much. She's a doctor. Kids were neglected. They weren't. Demanded full custody. When that didn't work, he escalated. Aunt's 72-year-old father was dangerous because he had weak eyes. Grandpa was in one fender bender. Suddenly, he's a threat. When that didn't work, he went nuclear. Accused Grandpa of molesting the 7-year-old. Claimed both kids were products of incest between aunt and her father. Why? Because they were too close. She's his daughter. They're close because he raised her and now helps with her kids while she saves lives at the hospital. The evidence of their inappropriate relationship? They hug. He picks kids up from school. They have dinner together. He lives nearby. Judge, sir, are you seriously claiming your wife had children with her own father? Uncle, look how close they are. It's unnatural. Judge, it's called a healthy family relationship. Meanwhile, the kids are traumatized. 11-year-old daughter locks herself in bathrooms when dad visits. 7-year-old son says, I want to kill him. A 7-year-old expressing homicidal thoughts about his father. Uncle still gets supervised visitation because parental rights. Kids sob through every visit while he remains oblivious to the damage he's caused. He's so focused on destroying his ex-wife that he can't see he's destroying his children. Accused their loving grandfather of the worst crime imaginable just to win points in court. Some people will burn everything down rather than admit defeat, even their own children's mental health. The aunt and grandpa are fighting to terminate his visitation. Hopefully, the court finally sees that some parents don't deserve the title.